Hi, this is a really powerful update. I'm glad you're watching today, Jeff Jink's Law. And I want to bring to your attention a case that just came down from the Indiana Court of Appeals a week ago. The case is super important for anybody that's buying or selling real estate. This is an investor series of transactions that went along, and basically the Court of Appeals decided that the initial title company didn't do their work properly, didn't verify that there was proper authority for one of the people to sign documents at the closing table. And so that transaction is void. And then all the transactions that went forward with these properties were also void. So it took it back to the original owner. And this is incredible. It's an incredible result because you've got a fraudulent business partner trying to take advantage of another business partner. And then all these people bought homes out of this investment portfolio over the years, and those are now all collapsing back to the original bad transaction. So what happened was, very simply, there were two partners in an LLC, very common structure for a closely held business, very common structure for a real estate investment deal. So this little LLC owned maybe half a dozen properties. I can't remember the number, but they owned several. And only one partner in that LLC, one manager, was appointed to legally have authority to sign documents on behalf of that company. Well, there became a dispute among those owners, and the other non-authorized partner decided, I want to sell these properties. I'm going to sell them. I'm not going to tell my other partner what I'm doing, and I'm going to forge that onto the closing documents that I have legal authority to enter into this transaction. So this out-of-state person signed a couple documents. I'm not going to go into what it was, but she went to the closing table, sold these properties, all of them out from under her partner, and got paid for them, didn't give any money to her other 50% owner who really had authority to sell them, did it without his consent, did it without his authority, and kept all the money for herself. After that portfolio of properties was sold to another investment group, they started parceling them out to other buyers down the road. They made improvements, they sold them, they fixed them up, they rehabbed them, right? A typical deal, right? You buy a property, you fix it up, you flip it to the next person or a final end user. And that went down the chain of title several different layers. And so all these buyers downstream are thinking, hey, I've got good title, there was title insurance, I can buy this property, I'm going to be the owner of it. Well, that's what the trial court said. Correct. Bona fide purchaser in good faith. You had no idea what happened back there. You had no idea this was fraudulent back at the beginning by this errant partner. And so your title is good. You get to keep the properties. Court of Appeals said, no way. We're going to go back to this original transaction, look at the way it was conducted, and whether or not the documentation was sufficient to make it a valid transaction. The Court of Appeals said, no, we don't think this was a valid transaction. The due diligence that was done by the title company was essentially not enough, and that they didn't really look at the things that were being signed, and that it wasn't done with proper corporate authority. It wasn't done by people even who had the authority, right? So that original transaction, it's all coming back to them, was void, and everything in the future was invalid as well. So all these buyers all the way along have claims against the person upstream from them and saying, hey, you sold me a property that you didn't really own. And you sold it to me, you didn't own it. And you sold it, right, all the way back to the beginning. So there's so many parties in this case, it's unbelievable. But it all comes back to this original LLC that owned it, and a bad partner who tried to take advantage of her other partner, kept all the money for herself. So kind of the silver lining to all this is that everybody had title insurance. All of them were battling each other. It's going to go back to the first title insurance company to pay all those claims off ultimately. But I hope that that title company, since they were so lame in the way they handled it, I hope they're valid. I hope they're solvent. I hope their agency is good and everybody's going to collect. Otherwise, these people that bought these properties downstream, not good. Not a good result, right? So really, really problematic. Uh, Full disclosure, I knew one of the parties in that transaction professionally, and interesting the way this case ultimately went out. We also represented another party in the case as far as a cross claim. So we weren't part of any of the transactions that happened, but one of my clients ended up in this litigation suing, cross claiming for damages that they received that were really unrelated to this. It was construction work that wasn't done correctly or went over budget and that kind of thing. We won that litigation. That litigation has not been set aside. So we're happy about that for our client. But just a stunning result that how are you ever going to know that all these transactions back in the day, years ago, or multiple transactions backwards in history are valid or not valid? Right? Who had the right corporate authority? So at the end of the day, you got to do your due diligence, and you better use a good title company, right? You got to use a good title company. And, we don't do title work, of course. We're not an insurance agency. But you got to really be careful with these transactions because here they are. It's all been collapsed back to the beginning. Very important case, stunning result. In my opinion, I thought the trial court got it right, but that's why I'm not on the Court of Appeals yet. Anyway, this is Go Properties versus BER Enterprises, Mortgage Electronic Registration Systems, right, et cetera, et cetera, et cetera. The citation is 18A as in appeals, dash PL like plenary, dash 176. Case was decided September 21st of this month of this year, 2018. Check it out. You won't believe it. It's amazing reasoning and an amazing result. Very powerful. We'll see if it goes up to the to the Indiana Supreme Court and where they're going to end up ruling on it. Two of our staff members, Tim Hawkins, who you've met, and Scott Penny, both went to that oral argument. I wanted to see what happened. They both thought by going to the oral argument that the Court of Appeals was really going to rule the other way, that they were going to side with the trial court. They were going to go down the path of good faith purchasers were protected, but they didn't. It was all the exact opposite. So you have no idea what these judges are thinking when you're in court. That's the second lesson here. We have no idea. So they were just hammering on plaintiffs' lawyers, and ended up actually ruling in their favor. So it's you never know what's happening in their minds and why they're arguing the way they are. You cannot predict what a court is going to decide in advance, even based on your personal experience being in the courtroom live while it's happening. You got no clue. Be careful. Settle your case up front, right? Get these things resolved because you have no idea what these courts are going to do. I'm not saying they're making bad decisions. I'm just saying it's unpredictable, right? Best lawyers in the world, you have no idea what's happening when they go behind closed doors and make their decisions. So be careful. Call us if you need help with any real estate related matters. We're happy to jump in and do our best for you. Thank you.